Representative, you said both in committee and on the floor just a minute ago that this does not change EMTALA or the interpretation and guidance to emergency providers that has been for decades the guidance from EMTALA. Is that correct?
That is what I would say to that, Representative Hauter, is that we're trying to maintain the status quo, but we also know that the Supreme Court has taken up a case with regards to EMTALA. So what we want to do here in Illinois is that in case that the Supreme Court limits EMTALA and it creates confusions around emergency treatment in Illinois, that we ensure that in Illinois we're maintaining the status quo.
So your contention is that if the Supreme Court changes EMTALA, that we're now going to go by your law and not EMTALA?
What we want to make sure is that we are keeping the status quo as it is right now.
So you're so correct. You're saying that we should now emergency providers should follow your law and not the interpretation of EMTALA and the Supreme Court's decisions. So is your legislative intent that EMTALA is now dead if it's not decided your way, and we should now go by your law?
What I would say, Representative, is that we don't know how the Supreme Court is going to rule in this particular case. And as we know, in the particular lawsuit that we're talking about when it comes to EMTALA, this has been because states that have banned abortion have argued that they can prevent doctors from providing abortions when it is a stabilizing treatment necessary to resolve a medical condition that can cause death. What we want to make sure that we do here in Illinois is that we continue to maintain the status quo so that we are able to make sure that if somebody goes to an Illinois emergency room and an abortion is the standard of care in an emergency, that is actually something that can be done.
I'm still confused. Is EMTALA the law of the land and the guidance to emergency physicians, or is your law the guidance?
Currently, EMTALA is the law, and we're trying to maintain that here in Illinois as well. We want to keep the status quo.
Okay. If EMTALA is decided that is adverse to your opinion, then we're going to go by your law?
Could you repeat the question, please?
So if there's an adverse opinion from the Supreme Court and you don't like it, we're going to go by your law or EMTALA and the Supreme Court's decisions? I'd like it to be on the record what guidance that we're going to go by. If the decision from EMTALA and the Supreme Court case out of Idaho is adverse to your opinion, then emergency physicians should no longer follow EMTALA, they should follow your law.
If federal protections are removed, state protections will remain in place.
Okay, we'll just move on. I don't think that's clear, but your bill has conditions that contends that abortion is a stabilizing treatment or should be considered as a stabilizing treatment. Do you add to the guidance from EMTALA in your bill?
I don't believe we do, but give me just a second.
Well, I'll help you with that. In fact, you do add to the guidance from EMTALA. You say risks to future fertility should be considered, abortion should be considered as stabilizing treatment, and also premature rupture of membranes. You do realize the risk to future fertility is a huge, broad possibility of cases that abortion should be considered as stabilizing treatment. Do you contend that there's many viral illnesses that are a risk to future fertility? Is it your position that a provider, hospital, or physician should consider an abortion to be offered as stabilizing treatment if a woman has a viral illness in the emergency department?
Representative, I understand your question. I think one of the things that, and I mentioned this during committee, right? One of the things that we're trying to do here is we want to make sure that we maintain the status quo. And there are instances when an abortion is actually something that's needed in order to make sure that stabilizing care is provided. For example, and I'm gonna say this example again, we had a pregnant woman who was 22 weeks along when she was brought into an Illinois hospital after experiencing seizures. At the hospital, this patient learned that she had elevated blood pressure, preeclampsia, elevated liver enzymes, and other conditions, and these complications made her pregnancy life-threatening. Her provider administered multiple medications in an attempt to control her blood pressure, but the patient's liver function was still going downhill. And despite the fetus's cardiac activity, it became clear that terminating the patient's pregnancy would be the best treatment to save the patient's life. So the physician performed an emergency surgical abortion. And in another state where abortion is restricted and EMTALA is ignored, this patient may have had to wait. As physicians, hospital administrators, and legal representatives debated her condition, but thankfully in Illinois, she received timely care. So there are cases where that might actually be the standard of care.
Okay, so in Illinois, was any woman being denied an abortion prior to your bill being introduced? You mentioned another state. I'm talking about Illinois.
We have protections here in Illinois.
Okay, so
And we
there's.
have EMTALA.
So why is your law necessary?
Because EMTALA may be narrowed due to the Supreme Court decision in June.
So when it's narrowed, and if it's narrowed, we should then follow your law, and it will supersede a federal law?
If it's narrowed, we want to make sure that we're safeguarding EMTALA as is here in Illinois.
Okay, it's very difficult for me to understand. So there was no restrictions to abortion in Illinois. If there's restrictions by the Supreme Court to EMTALA, then we're supposed to follow your bill and not EMTALA.
What I would say, Representative, is that if EMTALA gets narrowed down due to a Supreme Court decision, we want to make sure that in Illinois we have protections and keep the status quo as EMTALA is currently.
To the bill. Is anyone confused on why we're adding to EMTALA or we're superseding EMTALA? I am. I've been practicing emergency medicine for 27 years. I've never been involved with a case or heard about a case where abortion was necessary to stabilize a patient. And if it happened, if it was needed, current Illinois law would not prevent it. And finally, EMTALA guidance has never been in question. So what we have here is confusion from clarity. This is what happens when lawyers try to practice medicine. Today we vote on another abortion bill that was conjured up in the last week from a shell bill with very little input from stakeholders, let alone the citizens of Illinois. Mr. Speaker, we are changing decades of guidance and long, clear interpretation of EMTALA that always emphasized reasonable medical judgment, focusing the medical efforts on stabilizing the mother and her unborn. This bill adds conditions, confusion. It emphasizes abortion where it would never be considered. It'd be contraindicated, it'd be dangerous, and implies doctors, nurses, and hospitals must prepare to perform or offer elective abortions to resolve acute medical conditions of pregnancy. Or maybe not, I don't know, it's confusing. I hope Illinois physicians continue to provide care to both the mother and the unborn with the highest standards of medical care and ignore Illinois' abortion politics. Vote no.